Hello, my name is Josh Floyd. I'm an attorney at the Jimenez Law Firm.
And my name is Christina Jimenez, and I'm also an attorney here at the Jimenez Law Firm. And today we are going to talk to you guys about driving while intoxicated and kind of give just some basic general information about DWIs. I am going to let Floyd take the lead when it comes to talking about most of these topics, just because he is far more familiar with them than I am. And so with that being said, Floyd, why don't you tell us or give us kind of the basic definition of a DWI?
The DWI, you can be convicted of DWI if you operate a motor vehicle in a public place while intoxicated. That's the kind of baseline definition.
All right. And so we have actually had a few jury trials with DWIs, and with all criminal offenses, what we typically do is we break down the legal definition or the legal elements of whatever the alleged offense is. And so for today's purposes, what we're going to do is we're going to take that standard definition, we're going to kind of break it down. Okay. And so the first word being operating. Floyd, why don't you tell us, I guess, kind of the technical or the layman's definition of operating?
So operating is basically if you're using it, right? That's kind of what the element means. Are you using the motor vehicle?
Okay. So we've had several kind of consultations and or, cases that we have handled where someone will come in and they will say, well, I was laying in the back seat of the car because I was exhausted, or, I was sitting in the passenger seat. So talk to me about that situation and what do you think? Is that technically operating?
It depends, right? And that's the deal with criminal law and the elements. There's a lot of factors that go into whether or not you'll satisfy the element, but if they could convince a jury that you were operating, right? So if you're the only person in the vehicle and the vehicle is turned on, right, then presumably you operated that motor vehicle. If there's multiple people in the vehicle and they can't determine who it was that was operating, then they may not be able to prove that you were operating the motor vehicle. It just depends on the circumstances.
So that reminds me, Floyd, of that case that we had where we represented a young lady and we took the case to jury trial, and she was the only person at the scene when the police arrived. And I guess for the purposes of today's conversation, let's just call her Jill. So Jill comes in, she hires us because she has been arrested for driving while intoxicated. And basically what happens is, I guess someone was driving this vehicle and they hit a wall as they were driving down the highway. So police show up and our client Jill is the only person at the scene. She's not in the vehicle, she's standing outside of the vehicle.
I think she was in the passenger seat.
You're correct. She was in the passenger seat when the police arrived. Thank you. And so when the police interview her, she explains that she had been out that evening and that she had met a young gentleman that she was going to go home with or go
Jack.
to.
Call him Jack.
Jack. Yes, she met Jack. Jill met Jack at the bar. And as Jack is driving, I guess he hits this divider and he takes off running. And so I guess when the police get there and they start doing their investigation, they surmise that perhaps Jack did not actually exist, and they ended up arresting her. And so that was a really fun jury trial, and we actually did get an acquittal out of it because our argument to the court was, or excuse me, to the jury was that they could not prove beyond a reasonable doubt that Jill was actually operating the vehicle. And thankfully the jury, was supportive of our contention and we ended up getting a not guilty. So that was pretty cool. So Floyd, I guess, anytime you find yourself in this situation, and I've had it happen, I don't know, several times, where a client will say, I was working overnight and I just pulled over, just to sleep. Is there anything that you can recommend if in that situation to kind of mitigate those circumstances?
Well, under your scenario, they haven't been drinking, right? They were working, so there would be no problems. But if you have been
Maybe
drinking,
they had, and they had been working as well, then what happened?
I mean, it's best to call an Uber, right? It doesn't leave any room for error. But pull over to a parking lot, a public parking lot, maybe where cars frequent in and out. Don't leave the vehicle running. You at least have some argument that maybe you're not the one that operated the vehicle to that parking lot. But if you pull over to the side of the road and the vehicle's running and you're the only one in it, it's hard to make that argument.
Right. So best bet, just don't do it.
Right. Exactly.
So next element would be a public place. And we've had people that come in and they say, well, I pulled into a parking lot, right? Or I was just sitting in my driveway, and so I wasn't out, on the public roads. What do you think about that, Floyd?
Yeah, a lot of people don't believe a parking lot is public. It actually is. So public place is anywhere that the public readily has access to. And I remember years ago, I actually had a DWI dismissed on this grounds. He was actually arrested out at Texas Motor Speedway. And they were arguing it was a public place because it was a parking lot, right? But the problem was you had to pay to gain entry into that parking lot, which no longer made it public. And so we were able to get it dismissed on those grounds. And so where you are or whether it's public really depends on the circumstances, but as a general rule, anywhere the public has access to is a public place.
Very good. So next element is intoxicated, right? So tell me what intoxicated means.
So intoxicated, be a 0.08 or above, the blood alcohol content, or the loss of your normal mental and physical faculties, right? So can you function as you normally would under those circumstances? A lot of times that's difficult to prove because nobody knows what your normal is, right? But that's what they would have to prove.
So I've had that happen on numerous occasions where, a client comes in and they tell us, well, I have really bad vertigo and I can't, stand up straight if it saves my life, right? Or to save my life. I've had people with knee problems. So I guess when we're talking about that, we're talking about the loss of normal physical faculties, right? And so, typically we have to, or the person that's been detained has to do a field sobriety test. So I guess let's go there first and then talk about what happens if physically you can't do it, even if you're not intoxicated.
Right. So if you're suspected DWI, generally they'll do the standardized field sobriety test. There's generally 3 tests that they do. The first one is the horizontal gaze nystagmus test. That's the eye test. The officer has you follow the pen. The second one is a walk and turn where you'll walk 10 steps, turn and come back 10 steps. And then the third one that you see a lot is the one leg stand. The horizontal gaze nystagmus test is just testing your pupil reactions. Onset of nystagmus is basically when your eye shades, right? And so if there's nystagmus, it could indicate the use of alcohol. And then the walk and turn, the one leg stand, or presumably testing your ability to perform something that a normal person would be able to perform. And so in your situation, if your person wasn't a normal person, if they had vertigo and were incapable of performing that test under sober conditions, that's something we would just have to show the jury, is that this is his normal. Normally, he would not be able to perform this one leg stand, for example. And then, so that would be his normal. And if that's his normal and that doesn't change, then there hasn't been a loss of his normal faculties.
So I guess in that scenario, would you recommend that a person explain, potentially on video that, listen, I have a really bad knee. I can, barely stand up straight. I don't think I can do these tests in order to kind of help us when we get to the jury trial phase?
Yeah, absolutely. The officers are actually taught they should be asking those questions, right? Do you have any physical ailments that would prevent you from being able to perform this test, stuff like that. But in the event that they don't, yeah, you should also let them know. And if it's hurting, let them know, right? Why you can't perform the test.
And kind of just to that point, obviously, most officers these days, they have the body cams when they're doing these field sobriety tests. They have cameras outside of the vehicle. And then also a big one is they have cameras within the vehicle, right? In the vehicle, looking at the back seat of the vehicle. And I cannot tell you the number of times that we get hired on these cases and we start looking at these videos and, we have a client that's just passed out, wasted in the back seat of the car, or, we have someone who's acting belligerent and yelling and cursing. And, those things are most often very indicative of the fact that you probably have some sort of, either you're drunk or you use some sort of illegal substances. So just be mindful that everything you're doing is being watched. And if you're in the backseat of that car, don't pass out. I mean, you've just been arrested. Presumptively, you're going to be concerned and a little bit anxious. So best bet is just remain calm and stay as normal as you possibly can, because that's going to help us when we get to a jury trial. And so we kind of talked about, alcohol. Talk to me about drugs and how do we deal with that?
So same thing. I mean, a DWI in Texas there's not a different offense for drugs or alcohol, right? It's just a DWI. If you're intoxicated by alcohol or some other substance, illegal drugs or some other substance, even prescription medication, right? You can be intoxicated by consumption of prescription medication you have a valid prescription for if you have a loss of your normal mental physical faculties and are operating a motor vehicle, right? So even something you're prescribed, you can't take it and operate a motor vehicle safely, you can be convicted for the offense.
So if you're using drugs, is that something that when they do the breathalyzer that they'll be able to recognize?
Not the breathalyzer, no. They'll usually do a blood test if they suspect that you're intoxicated by something other than alcohol.
Okay. And so talk to me or explain, what the blood test entails and, how they go about doing that.
So they'll take you down to the hospital. Some police departments have the technicians there that can draw the blood. There's very specific procedures they have to follow before drawing the blood, like a checklist they have to fill out and all this, and how many times they have to turn the vial, all kinds of technical stuff. But basically they draw the blood, they send it off to the DPS lab, and then it'll come back and quantify your blood alcohol content for alcohol. And I guess blood alcohol content for alcohol, that didn't make sense, but the amount of alcohol that's in your blood. And that'll give them the number just like it would on a breath test.
And so is this something that if you are pulled over, is it something that you have to agree to allow them to test your blood and or your breath? And do you have to agree to the field sobriety test?
No, and no. So we'll start with field sobriety test because that's what comes first generally in the situation. You can refuse field sobriety test. It'll be used against you as evidence of intoxication later, the fact that you refused it. And then with the breath test, you can refuse it as well. Again, that's information that can be brought before the jury that you refuse to give a breath test. If you refuse the breath test, they do have the ability, well, then they can request blood, right? And if you refuse the blood test, they can get a warrant issued and actually physically take the blood from you if they have enough probable cause.
Okay. And so I guess I'm going to skip ahead and talk about what is the impact of refusing the breath and or I guess refusing the breath test.
So I presume you're talking about driver's license suspensions, right?
You presume correctly.
Okay. So if you refuse a breath test, your driver's license is going to be suspended for 180 days, an administrative suspension from the state of Texas. If you give them the breath test or the blood test, whatever it is they ask for, and you fail it, your driver's license will only be suspended for 90 days.
Okay. And so tell me, I guess, the process of the driver's license suspension.
So when you're arrested, if they do breath, and if you refuse breath, then you'll have a hearing. You have the right to a hearing. You can request that. You have to request that hearing within 15 days of the date that you're arrested, an administrative hearing. Once you request it, we go before the administrative judge and argue whatever your issue is, right? Whether they didn't have probable cause for the stop, the arrest, whether it was a valid refusal, valid breath test, whatever the issue is, right? And we can argue to the administrative judge that something went wrong and they don't have enough evidence to establish that you were intoxicated or guilty of the offense of driving while intoxicated. And then you will not have that driver's license suspension. If you do not request that hearing, then your driver's license suspension will automatically take effect.
Okay, very good. And so that's obviously conviction, right? So this is something that happens before or immediately, almost after you're arrested and you refuse. What about after the conviction?
Yeah, so you can get an additional suspension after conviction as punishment for violating the penal code. On a DWI first, the suspension period is 90 days to a year. But you can do a DWI safety class and the state will waive that suspension. But generally speaking, it's 90 days to a year on a DWI first.
And is there something that people can do if their driver's license is suspended?
Generally speaking, yes. You can get an occupational driver's license. There's very few circumstances that don't allow for it, but generally speaking, yes, you can get an occupational driver's license.
What is an occupational driver's license?
It's a driver's license that allows you to go to work or perform your normal daily functions.
Very good, Mr. Floyd.
Thank you.
So I guess the last topic are the different types of driving while intoxicated offenses and kind of the range of punishment for each of them. So talk to me a little bit about that.
So there's several intoxication offenses, but specifically we'll focus on DWIs. You know, with the DWI first, it's a Class B misdemeanor. The punishment range on a DWI first is 72 hours to 180 days in jail and a fine not to exceed $2,000. If you get a DWI while you have an open container in your vehicle, it increases from 72 hours as a minimum to 6 days as a minimum. So it's the 6 days to 180 days, and the fine is still at $2,000.
So just so everyone's clear, basically what you're saying is if you're pulled over for the first time and you have an open container and you are sentenced to jail, the minimum amount of time that you would have to go to jail is 6 days, correct?
Correct.
Okay.
Correct. And then also for DWI first, if your blood alcohol content is above a 0.1 or 0.15 or above, then it's automatically enhanced to a Class A, which then makes your punishment range 0 to 1 year in jail. That would also apply, I guess, if it's your second, if you have a blood alcohol content of 0.15 or above, it would be a Class A. But a second DWI is a Class A anyway. The difference is with a second DWI, instead of your punishment range being 0 to 1 year in jail, it's 30 days to 1 year in jail on a DWI second, and a fine not to exceed $4,000.
Okay. And what about, and I don't know if you covered this or not, but if you have a child in the car?
If you have a child in the car, it doesn't matter which DWI, first, second, third, whatever, it's a state jail felony. Punishment range for a state jail felony is 6 months to 2 years in state jail, which is prison, and a fine not to exceed $10,000. And let me take that back. If it's your third, it's going to be a third-degree felony, which is worse than a state jail felony. So you could be charged with the state jail if you had a kid in the car, but they'll probably just charge you with a third-degree felony, which the punishment range on that is 2 to 10 years in prison, and a fine not to exceed $10,000.
Very good. Say that 5 times fast. So I guess in all of these cases, are they probation eligible? Can they get deferred? Talk to me about that. Does it automatically mean that we're going to jail?
That's a lot of questions. No, you're not automatically going to jail. Generally speaking, on your first and second offense, you're looking at probation, unless there's some extreme outrageous circumstances. You're probation eligible on all of them, assuming that you don't have anything else that bars you from being probation eligible. And what was your other question? There was 3.
I think that was it.
Deferred. There is a new law for deferred DWIs. but it doesn't give you all the benefits of a new deferred. So it really hasn't shown much of a benefit necessarily. Oh, and I forgot, with all of these DWI offenses, there used to be the surcharges where they added those surcharges to your driver's license. So they eliminated those surcharges now, and they have what they call a super fine, right? So in addition to the fines that I just talked to you about a second ago, on a DWI first, you can get an additional $1,000 fine. On a DWI second, it's an additional $1,500 fine, and DWI third is an additional $3,500 fine. So those are in addition to the other fines that we talked about.
So Floyd, I mean, we covered obviously a lot of information, but as we were preparing to do this video, you were kind of getting a little bit overwhelmed, and you're like, there's just too much to cover. Like, we can't possibly go over every single thing because it's always going to be different. And just like with all of our criminal cases, it depends on that specific fact pattern, right? There's always going to be that one little nuance that potentially we can hang our hat on to help our clients, right? And so, you know, with just like with every video that we post, obviously best practice is to go and visit with a local attorney, someone who you feel confident with, and explain your particular situation to them. And they will hopefully do the research and or, you know, negotiate with prosecutor, and potentially take it to a jury trial to argue those specific issues. Is that a fair assessment, Floyd?
That is correct. There's so many other variables that go into handling one of these cases. And let me correct myself, because I think I gave you the wrong numbers on the super fine. I think I gave you the surcharge numbers. The super fines for a first is $3,000. For a second is $4,500. And if it's 0.15 or above, it's $6,000.
Wow. Wow. All right. Well, is there anything else that we needed to share with regard to the driving while intoxicated offenses?
I don't think so. Just don't do it, right? There's a lot of ways to avoid it at this point with the technology. Don't do it. But if you do, find somebody that knows what they're doing to try to help you have it as minimum impact as possible on your life.
Great legal advice, Floyd.
Thanks.